Yes.
Okay. Chief Marie, I'll have you get with your lawyer and then they can get with pretrial.
And I start today. It starts today at 5 p.m., which is why she had to come today.
Okay.
So-
I'll have you get with Miss Freedy. She can get with pretrial. You guys can work out the details.
All right, thanks.
Judge, would you like me to email that proof of employment to you or to pretrial?
No, to Felicia. And I don't know if you have her email address. I'll see if I can get it for you.
Okay, please. I'll see if I-
Give me a second. I'll chat it to you. Hold on.
Okay, thank you, Judge.
Good morning, Mr. Williams.
The defendant is currently facing a theft charge. While it might seem like a minor offense in Texas, the consequences are anything but small. A conviction could result in up to a year behind bars and thousands of dollars in fines, making it a serious matter that shouldn't be taken lightly.
Sir, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On July 15, 2024 in Harris County, Texas, a defendant was observed on surveillance video entering a pawn shop.
This part is truly jaw-dropping. Hiding a $2,000 projector inside a baby carrier. It raises an important question. Should involving children in a crime lead to harsher punishment? Using a child in the commission of a theft not only add a layer of deception, but also crosses a serious ethical line.
By a female, a toddler, and a baby in a car seat carrier. The defendant was observed putting down the baby, picking up a projector, and concealing it behind an item on the next aisle. The defendant then returned to the baby, picked up the baby, and then picked up the hidden projector and concealed it in the car seat. The female completed a transaction at the counter, and the defendant left with the item in the car seat without paying, passing all points of sale. The defendant was identified by his Tennessee driver's license photo by the complaining witness. The value of the item stolen was $2,000 or $2,099.99.
Do we know if they got it back?
I do not. Does not say in the DIMS. I need just a moment, Your Honor.
This is classic judge energy. No room for excuses. After 3 missed court appearances, the message is clear. The next bond to be set sky high. The question is this a fair warning to ensure accountability? Or is it too harsh? Let's be honest. The court's patience isn't endless.
Cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this pawn shop. You've also missed 3 different times. If you miss, excuses go in one ear, go out the other. Actions are what matter, Mr. Williams. You've missed court on 3 different occasions. If you miss again, I'm going to make your bond so high, it's going to hit the clouds. Do you understand? Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll take a look to see whether you qualify. Okay. You get, every time you bond out, they give you paperwork telling you where you need to go, the date and time and the location. So I'm not going to argue with you, man. It's just, we've had 3 different occasions. Your case is 220 days old. So I'll have you fill out an application. I'm going to have you sign a receipt. I'm going to have you take a seat, but I need to do further bond conditions on him. So you're not allowed to leave until we do further bond conditions. Please, please.
We're approaching on Sean Williams. He's on today's docket.
This is the gentleman. It's a theft of the projector from the pawn. Okay.
Victoria told me I needed to approach about bond conditions. But if you're happy with them all.
Well, no, the thing is this case is super duper old, right?
Yes. And Judge, this was a 2B. And so that's part of the age. And then
It's a true 2B for like 180 days, and I don't have a problem. But if he's been on bond and then he takes off for 150, then.
So just my brief look at it, what looks like happened is it was a 2B. He got picked up. He paid an out-of-county bond. And
here comes a hammer. If no one's willing to put up thousands for your bond, you're stuck like Chuck. That's some courtroom slang you don't hear every day. But the message is loud and clear. Show up, take it seriously, or face the consequences.
His next court date was not clear to him. And
Come on.
so, he did bond forfeit. And then he paid another out-of-county bond, and he's here today.
Yeah, he's forfeited at least 2 different times. It's now 212 days on.
It looks like he's only bond forfeited once.
He's made.
You're conservative, man. It's a concern.
And again, any amount of bond forfeiting is bad, but
Discovery complete on this case.
Hold on, Counter. Verify that.
If you ever take off on me again, Mr. Williams, you know what's going to happen to the bond. And if you don't have anyone in this world that's willing to pony up 10,000, perhaps 5 to 10,000, you will be stuck like Chuck in there until this thing is over. Do you understand me? The only thing.
This is where things get serious. The monitoring device detected alcohol use, despite his excuses about lotion and work boots. But judges have heard all before. Those explanations don't hold much weight in court. When it comes to violations, the evidence speaks louder than the excuses.
In this world, I'm asking you to do is keep my county safe and show up. You pick up another case. You are unsafe to my county. It's really not going to go well for you. Do you understand me?
I do believe this, Your Honor. There's
I'd like you to do a writ first as well to see whether they got the projector back or not.
yes, Your Honor.
And then,
Judge, if we can just have a regular reset,
your regular reset.
that'll give me time to look at
You
everything.
must be here at the next setting. So we're going to decide what we're going to do with this case. But I'm going to tell you now, if they didn't get it back, it will be part of anything. That
Understood.
restitution is. All right, Mr. Williams, don't have any contact with these people. Don't have any weapons. Don't pick up any new cases. So I guess, Felicia, I'll have you do it as just because it'll be faster so we can get them out of here. Just no contact with any witness, no going back to the pawn shop, no new cases. No drugs, no alcohol. Okay. All right, dude. Good luck. See you in 30.
Okay.
Okay, so I have talked to pretrial in regards to the violations as to tampering with the scram.
You need a translator anyway, right?
I guess
Vicky
so.
Ramirez?
Yes. So, pretrial doesn't know exactly what was tampered with. He does work in construction. He wears boots. He wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says the scram actually has been causing him a lot of pain on his legs. So sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no like BAC, no alcohol, nothing. It was just
Because a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor to, evade. This is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 a.m. so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one,
And it says
began
alcohol was
at
detected.
on March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first.
¿dónde es?
Tengo que te estás, que tienes alcohol en tu sistema y que estás fallando con la máquina también.
No, sir.
La máquina me dice otra cosa. I don't know what to tell you, Ms. Solis, but
Oh, I mean, pretrial doesn't have knowledge as far as like what was the tampering. I mean,
they can't. It's impossible.
I know that, Judge.
All we know is that the device is not detecting his skin for a certain period of time, and at the same time, alcohol is detected.
¿Dónde estás el día primero y el día 8?
So let's do this. I need to get a translate here so I can properly translate and let him know what I'm going to. Oh, Plaza. Can I borrow you for a second, please? No, I just need you to help me translate.
Oh, okay.
Mr. Ramirez. You were instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I know, Judge. I mean, we're ready for plea today, but
up your bond. You're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back. And we'll see.
Yeah, because he does say he does use the creams on his arms and hands, so it doesn't have a BAC level or anything in regards to the scrum, so.
Advised of.
I understand, Judge, I understand.
All I know is that alcohol is detected and he's tampering with the device.
Okay, all right, Judge. All right, well, so I'll step out and then, okay, thank you.
What's up, man?
I'm here for Ricardo. He just said he just wanted to
Ricardo.
approach for an admonishment. So
Kim is here.
Oh, Dave's there. Okay. Hey, Dave. Sorry, man. I've been in different courts.
okay. I mean, if it's just for an admonishment, then I can just sit here. Like if it was something contested, it'd be different. But it's just literally it was the judge. It was the one we approached on Monday for the remand, and it's just I guess telling him about.
Do you want me to bring him out?
Yeah, let's bring him out. Can we bring out Mr. Joshua Sweat? Because I did want to talk about the reason why they're asking for an extension. And I talked to the client and I need to bring this up. So.
Not happy?
Well, it's part of it. I think you're saying that he's medically unfit to be transferred. I think that's the reason that.
Right. So, I mean, in plain speak, he's detoxing, and medical needs to figure out when they're finished with that before they can even Louisiana can even initiate the transfer. That's the issue, is they can't even tell when they're coming because he's not cleared yet for transport, ironically. So, yeah.
So that's something that I want to address with the client being here. Yeah, and sorry I waited till the end on this, Judge, but I've been running around. It's one of those days.
Hey, we're all feeling it. Don't worry about it. You're doing great. I'm tired too. And I still got to go fix a flat tire, man. I had a flat tire. Come on.
Oh no! Hey, Judge,
Huh?
you have AAA? You don't have AAA?
No, because through your insurance, you have roadside assistance. Yeah. I'm not gonna forgot to call him though. Hey.
How you doing, sir?
Notice a legal twist here. While many defendants assume they only have 14 days, the law actually allows for 30. That shorter time frame is more of a courtesy, mainly due to overcrowded jails. It's a big difference, and misunderstanding it could cost someone valuable time and options.
How are you, Mr. Sweat?
Pretty good. How about yourself?
Well, let's talk. You know, I think that you, if I remember correctly, you have a parole violation out of
Louisiana, Judge.
No, Michigan, sir.
Yeah,
Or Michigan. Sorry, Michigan. I'm sorry. I conflated two cases.
That's right. He was a Michigander. That's what we were saying. That's right. You know, a lot of times in life, You really have to read the fine print. You got to read what you're signing. A lot of people just sign just because they want to be done with it. Yay, I'm getting on probation. Yay, I'm getting on parole. Let me just sign what I'm going to do. You know, one of the things that you sign in the jurisdiction where you signed, where you refused, or I'm sorry, you waived extradition by signing the document that you agreed to be on. So whether you agreed to get on parole, whether you agreed to be on probation, you refused extradition by signing the document in and of itself. And it says there, I will, you know, waive extradition if I ever become a fugitive from justice. You are now a fugitive from justice, meaning that you're wanted out of the other state.
Yes, sir.
So you can't sit here and say, you know what, I want to try to get a bond so I can just go turn myself in. You have already you have what's called a pre-signed waiver. You have already signed.
Because that's why I was trying to get back.
We are going to get you back.
Yes, sir.
The problem is that sometimes, you know, we give them up to 30 days for them to come get you from Michigan.
I was under the impression it was 14.
In the typical instance where I don't give someone a bond, yeah. But for pre-signed waiver cases, it's 30 days.
Judge, and if I may, that's my argument. When we did all this, we always talk about the practice of 14 days. And so when we originally talked, we reset it out 14 days, and we were all basing it on